Beyond that, she held herself out as a specialist in diabetic counseling. She knew the impact insulin would make. That's our case, all circumstantial, and at the end of it, we'll be asking you to find the right verdict and find this defendant guilty of first-degree murder. Thank you.
Mr. Victor?
May it please the court, counsel for the state. Ladies and gentlemen of the jury, by the prosecution's account, and perhaps by some other accounts, Natalie Cochran is not a nice person. She defrauded friends, relatives, investors. She was involved in a Ponzi scheme. She cheated, she scammed. And she has paid for it. But ladies and gentlemen of the jury, the fact that she is perhaps a fraud and perhaps a cheat, and that you wouldn't perhaps want to invite her home for Sunday dinner, that you wouldn't like her, does not translate into being a murderer. This trial is not a forum on public acceptance. You don't have to like her. You don't have to say she is a great person. But you have taken the oath to judge her fairly and to give her a fair shake, a fair trial. When you took the oath, it's not just some wave of a hand. It is a solemn oath to search for the truth and to determine what really happened in this case. Now, the prosecutor presented a very nice theory, except that before we do that, again, I'm Matthew Victor. I represent Natalie Cochran with my co-counsel, Mr. Stanley Selden. We represent somebody, again, who is perhaps dishonest in her financial dealings, but who didn't kill anybody, let alone her husband, her only man in her life. A man, the father of her 2 children, and a man with whom she was enamored ever since she laid eyes on him in high school. She's not a murderer, as the evidence will show. Now, she is accused here by the state of West Virginia of one of the vilest crimes there is known. And I will submit to you that the state's motive in this case, as they presented to you, is absolute nonsense. The state of West Virginia is trying to tell you that my client, Natalie Cochran, who has lived with the man who was up to his eyeballs in the Ponzi scheme, somehow detected that he was on her. He was already detecting that she was committing a major fraud, and he was going to run straight to the federal government. Well, think about it, ladies and gentlemen, as you listen to the evidence. The state would want you to believe that he didn't know anything about the Ponzi scheme, he didn't know anything about millions of dollars and the lavish lifestyle. He didn't know anything about this, even though the evidence will show that he was signing all these contracts, he was working on the contracts, he was signing checks, and you will see that evidence, you will hear that evidence. And all of a sudden he found out that Natalie Cochran, his beloved wife, is a fraud and a cheat. And what was he gonna do? No, he was not gonna go and talk to her and try to resolve this case somehow, get a lawyer, whatnot. The evidence will show, well, at least the state's evidence will show, that she's gonna run to the federal government and turn her in and have the dear wife, the mother of his children, locked up in prison. Well, okay, think about that. As you listen to the evidence, be aware of the fact that she, that is, Ms. Cochran, does not have to prove herself innocent. The state has the burden of proof, beyond a reasonable doubt, to demonstrate that Natalie Cochran killed her husband with premeditation, deliberation, and malice. And that, ladies and gentlemen of the jury, the evidence will show the state cannot do. They cannot do it. You will see exhibits, you will see documents here, consider it all. But what comes to mind immediately is that bottle of insulin. And I will submit to you that this is a smokescreen that the state is going to present to you. You will hear expert testimony and evidence that this type of insulin could not kill anybody. And for that matter, that the amount of insulin that may have been given to Michael Cochran would not kill him. The state will not tell you exactly what happened that day. Well, they will tell you what they believe happened that day after Mr. Cochran was allegedly shot with this insulin. But what they will not tell you is that if you are shot with a injection of insulin, you're not going to drop unconscious immediately. Think about what would happen if somebody injected you with insulin. Would you react? Would you call 911? Now let's think about it. Let's also think about the fact that the evidence in this case is not exactly what the state believed you to be. Mr. Cochran was a 38-year-old man who died, and the question still remains, what did he die of? You will hear medical evidence that Mr. Cochran was not a healthy 38-year-old man. In fact, to the contrary, between the late 2017 and the time of his death in 2019, he was in the hospital 4 times. For what? For life-threatening conditions. He was a ticking bomb, the evidence will show, health-wise. He suffered from a plethora of medical conditions that could easily end up his life. What's more, you will hear the evidence that Mr. Cochran fancied himself to be a bodybuilder. He wanted to be the Arnold Schwarzenegger, Mr. Universe. And what did he do to that, in that regard? Mr. Cochran has imported, well, let's call it medication, from Mexico, online, from sources that were not approved by any FDA or any legitimate American government sources. And he was taking medication, steroids, that were not for human consumption. That there was some animal medication taken only by the animals. So consider that. Consider that. He was not a healthy man. He was in the hospital in 2017 for his back problems. Let's maybe even disregard that. But he was again in the hospital for mold exposure, with the symptoms similar to what happened to him in February of 2019. He hated the hospitals, the evidence will show. He told everybody that if they ever took him to the hospital, it would be a waste of money, and he would not want to stay in a hospital. But 2 days later, he was again in a hospital with the same conditions, even worse. Somehow he survived. His medical conditions, you will hear, involve the swelling of the brain, convulsions, perhaps epilepsy. You will hear all that evidence. He was not a healthy man. And he refused to take medications. He was pumping himself with steroids and whatever other medication there was that he could get from less than legitimate sources. And you have to consider that in arriving at your verdict. Secondly, the evidence will show that the state's medical evidence as such is going to be easily discredited by the expert evidence of people who, expert witnesses, who will tell you that this type of medication, what he had, could not have killed this man. And on top of that, the facts of the case are also different from what the prosecution told you. In fact, the insulin, you will hear about all this insulin. This is a smokescreen. The insulin that my client had in her possession was the insulin that Mr. and Mrs. Davis gave her repeatedly. Why? Because they had a diabetic son. And Natalie was an expert in administering that medication because their next door neighbor had a son who had diabetes 1. Sad to hear that, but that's the reality of it. It was not a one-time deal. She was in fact entitled to go to the pharmacy and get that medication, pick up the medication for Mr. and Mrs. Davis's son. So the fact that she had any insulin in her home is of no import. Furthermore, the state will present the evidence that they found a bottle of insulin in her home. We will, however, present to you that that bottle of insulin was first of all full, so nobody took that insulin. Second of all, that insulin was found in the refrigerator 4 months after Mr. Cochran's death. That insulin is completely irrelevant, as the evidence will show. Now, the state wants you to believe that Ms. Cochran, as a pharmacist, is knowledgeable of the insulin because she wanted to kill her husband. The evidence, however, will show that Ms. Cochran, as a pharmacist, is also known to have great knowledge of any other substances that could kill, undetectable, untraceable. And so consider this evidence. Let's assume that the state is right on everything. Consider the fact that this cold-blooded killer borrows a murder weapon from a neighbor to kill her husband with the insulin that involves now a couple of witnesses. Then she places that medicine in her refrigerator, the evidence of the crime apparently according to the state, for 4 months. And then she somehow does not use any other substances that she knows of because she is a pharmacist. That theory is absurd, ladies and gentlemen. Truly. And now, the kicker. She has an absolute power to hide the evidence. And the evidence will show that she had never cremated her husband. So he was exhumed, his body was exhumed, so that the state could prove something, which the state cannot, but at least they tried. And we will submit to you that if she had cremated the late Mr. Cochran's body, there would have been no case. There would have been any case. Now, you will hear the evidence about her chemo treatment. You will hear the evidence about her health. And, ladies and gentlemen of the jury, after all of that, you will come to the realization that the state's case doesn't make any sense. And you will not be able to answer your own question, perhaps. What did this man die of? Certainly not the insulin injection. And the evidence will also show that Mr. Cochran, by the state's own admission, was enjoying the benefits of Ms. Cochran's fraud. Well, that's another red herring. He was involved in the Ponzi scheme. He knew about multi-million-dollar purchases, the toys, the houses, trips to Paris, trips to Hawaii, expensive, lavish lifestyle. And you have to ask yourself at the end of the case, he didn't know about it? Really? He didn't know how this money was generated? He who wrote all the contracts for the government, for the non-existing purchases? If you cannot answer these questions, then you have to acquit the defendant. This is a complex case, ladies and gentlemen of the jury. But it's built by the state of West Virginia on conjectures and innuendos. It is rich on spurious conclusions and speculations. But it's thin on facts. And glaringly lacking in motive and the evidence necessary to prove that my client killed her husband. At the end of the case, we will ask you to find her not guilty. Thank you.
Members of the jury, the next part or stage of this case is the introduction of the evidence through witnesses and exhibits. This is what lawyers and judges call the heart of any trial. You are to determine the facts of this case solely from the evidence. As jurors, it is your duty to listen carefully to and observe closely all witnesses and evidence to assess the weight of the evidence and the credibility of each witness. As I explained to you, because the state has the burden of proof, the state goes forward first. Mr. Truman, you may call your first witness.
Thank you, Your Honor. The state calls Robert Heinzman.
You will raise your right hand, please, sir. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may have a seat right there. And Mr. Truman, if you will give me a prompt at the proper time.
Yes, sir. Thank you.
You wish for me to proceed with both instructions?
No, sir.
Go right ahead.
You are Robert Heinzman.
Yes, sir, I am.
Tell us your background in education and employment, please.
My name's Robert Heinzman, and it's probably best if I go chronologically from my first professional job to present to help keep things in order. I joined the United States Marine Corps in 1989 and got discharged in 1993 off of active duty, and joined the Beckley Police Department here in Beckley as a law enforcement officer. I worked at the Beckley Police Department 4.5 years and applied for the West Virginia State Police, and then was hired by the West Virginia State Police in 1997. I stayed with the State Police until the year 2000. I left law enforcement and went into doing private investigation for about a year for a local attorney here in Beckley. In 2001, I went back into law enforcement, worked at the Bluefield Police Department for 2 years. I was doing that while I was finishing an undergraduate degree at Bluefield State College. Finished that in 2003, went back into the private sector, came back to Beckley, worked for a law firm here doing civil investigation. I did that for about 3 years, and I was then recruited by a former law enforcement officer that I worked with, who was now working with the West Virginia State Insurance Commission's fraud unit. It was a new unit that had been created in West Virginia around 2015, 2016. So I joined that unit and did insurance fraud investigation for about 6 years until the state police had called me and then recruited me to come back to the state police because they wanted to stand up a financial crimes unit inside their Bureau of Criminal Investigation. They didn't have anybody doing that. They needed someone with some experience doing fraud investigations, so I went to the state police in 2013 and stayed there till 2019. In 2019, I applied for law school here in West Virginia and went to move to Morgantown, attended law school starting in 2019. Law school is 3 years long, so I did that for 3 years. And then after law school, I took the bar in 2023. I was accepted to the state bar. I'm now a practicing attorney in Morgantown, West Virginia. I opened an office there, and I'm in my second year in private practice in Morgantown. And that's my storied career, part of it.
Was this case your last case in law enforcement?
This was the last criminal investigative case that I worked before I left the law enforcement community.
Your Honor, I ask that this be marked as States 1 for identification. Your Honor, I believe it'd be appropriate to read the 2 cautionary instructions at this time.
All right, members of the jury, normally the court would read to you what's called the jury charge at the end of all the evidence and before the closing arguments. Sometimes during the trial, the court must read to you a limiting or cautionary instruction, and that time has arisen. So I read to you these 2 instructions. The court instructs the jury that evidence of other crimes, wrongs, or acts by the accused is not to be considered to prove her character in order to show that she acted in conformity therewith. However, the jury may consider such evidence for other purposes, such as proof of motive, opportunity, intent, preparation, plan, identity, and absence of mistake or accident as to the crimes charged. The court has or will take judicial notice of court documents generated by the United States District Court, Southern District of West Virginia. That is, the court has or will take as a fact that the litigation in the United States District Court, Southern District of West Virginia, occurred based upon the determination of sources whose accuracy cannot reasonably be questioned. You are instructed, however, that you may or may not accept that fact as conclusive. All right, you may continue now, Mr. True.
Your Honor, before we begin, may defense counsel be shown the exhibit so we are on the same page?
Sure.
Show it to Matthew. We can see both. Bob, I hand you what's been marked for identification as State's Exhibit 1. Can you review and identify, please?
Yes, sir. These would be the federal documents. The financial crime in this case was charged through the federal government. So these are the federal documents that certify that an agreement was made by Ms. Cochran to plead to certain financial crimes, federal financial crimes, to resolve the financial crime that occurred with this investigation.
This was your last criminal investigation, correct?
Yes, sir.
And State's Exhibit 1 reflects the finality of that investigation for that part of the case. Is that a fair assessment?
It does.
Tell us some background as to what that case was about. What's a Ponzi scheme?
Let me start by saying that I just didn't go from law enforcement into doing financial crimes.
I'm sorry, I'm going to object. We don't need all the background. Let's just answer the questions.
All right, I'll give the witness some leeway. Sir, you can explain. Go ahead.
I have training in financial crimes. I'm a certified fraud examiner through the Association of Certified Fraud Examiners. I have a master's in forensic accounting. During the course of that education and training, couched with the experience of conducting financial crimes over that 13-year period with the state police and with the Insurance Commission's fraud unit, as well as some other financial crimes that I worked during my uniform law enforcement days, I come to learn about the different various types of fraud and financial crimes that occur in society. So when I say fraud or I say financial crime or I would say maybe a scam, I may use some terminology that's more or less synonymous as I discuss this. So if you hear me say fraud or a scheme or scam, I'm generally talking about the same thing. The financial crime aspect of that term would apply to the violation of law or the criminal charge. So when we say a Ponzi scheme, we're talking about a type of fraud. And what a Ponzi scheme is, the term Ponzi is a name coined after a con man in the 1920s. So Ponzi itself means nothing, but the Ponzi scheme is a methodology of fraud. And what that is it's an illegal business practice where someone would induce a person or a victim to invest money into a business, and then they would continue to get investors to invest money in the business, but later investors' money would be paid to earlier investors' money, and then that cycle would just continue over and over. So as new investors would invest in the business, then monies from that investor would be used to pay earlier investors. Now the investment could be a number of things, but that basically is what a Ponzi scheme is: taking new investor money and paying earlier investors on money that they were supposed to receive from their earlier investment.
What do you look for when you suspect a Ponzi scheme? Ponzi
schemes are generally involving business. So when you're looking for certain red flags or certain red flags that may, with many scams and schemes and frauds with the Ponzi scheme, if the investment opportunity, the very first indicator is that it sounds too good to be true. When that sounds too good to be true, that's typically the initial indicator or red flag. There may be promises that this investment is very low risk. You know, people who want to take their hard-earned money and invest it in something to get money back want to make sure that they're not going to lose money. So there's typically a high reward with a low risk involved with inviting or inducing someone to invest in a company or a business. And then there's opportunities to reinvest that money. You know, if you've earned this money and there's opportunities to reinvest. So there's different red flags, and they're not all, the indicators aren't always present in all scams or schemes, but those are some of the ones with the Ponzi scheme.
In this particular case, how did you become aware that there was an investigation to be opened?
This investigation opened from a businessman here in Beckley who was who was part of this overall financial
Your Honor, I'm sorry.
crime or scheme.
I'm going to object. Can we approach the bench on this one?
Sure.
Thank you, Your Honor. You can go ahead and answer the question. How did you open this case?
A local businessman who was involved with Miss Cochran's business called a state trooper or ran into a state trooper that he knew who and asked, he was having problems with.
Now I'm going to object to hearsay, John.
This is Danny. I think we need to cut to the chase.
Okay. You opened an investigation,
Yes,
and you determined that the defendant was in fact operating a Ponzi scheme.
yes. The defendant had a business and was operating a Ponzi scheme.
In summary fashion, what was the overview of the business that she pretended to have?
The business purported to be a supplier of durable goods and other materials to government contracts. So the federal government would need to buy supplies or goods. They would put out an announcement for businesses to bid on these contracts to fulfill their needs. And then federal contractors, businesses would bid on these contracts, get awarded the contract, then the business should supply the good to the government and get paid for the good they provided. That was the purpose of the business. That's what the business purported to be.
And you did an extensive investigation that culminated in the federal conviction that you have at State's Exhibit 1, correct?
Yes.
Now, the defense has floated the theory that Michael Cochran was up to his eyeballs in this Ponzi scheme. From your investigation, do you have any evidence that would support that?
Let me state by saying the business itself, in its appearance, in its existence, was legitimate. The business was legitimately set up. It was registered with the state of West Virginia. It was registered with the federal government. So Michael Cochran was aware of the business, and because he participated with what he believed was a legitimate business.
I'm going to object, Judge, as to what Mr. Cochran may have believed. That's calls for speculation.
You can continue, please.
So during our investigation, we reviewed many financial records, many documents to determine if any government contracts existed, any federal government contracts had been awarded to this business, and we could not find any contracts whatsoever where the government had awarded these. Now there was one state of West Virginia contract that was that Mr. Cochran had, or the business had bid on, but they never fulfilled that contract. So beyond this one contract, there were never any contracts that we could find to support what the business purported to do. Also, in reviewing, there were allegations to financial institutions, and those documents only bore the name of Mrs. Cochran in the business, and those documents would purport that she was a 100% owner of the business. So there was a suggestion or an indication that Mr. Cochran didn't know about certain documents that because he wasn't listed on certain documents. In addition to that, the victim investors of this were given reasons. They were given information to induce their investment. They were given information regarding them getting their investment money returned to them, the money they should have earned on their investment. So the information that was false or deceptive that was being given to victim investors of the business was the exact same information that was being given to Mr. Cochran when he would question why the business hadn't received its money from the contracts. He did participate in looking for contracts for the business to bid on, but that was about the extent of his involvement. He would search the internet and the federal websites to identify federal contracts that the business could bid on. But the structure was that Mrs. Cochran would go out and secure those contracts from the government. So as far as Mr. Cochran knew, based on the records that we reviewed, the interviews that we did, he believed that they had obtained contracts and that they would be receiving money for these contracts. So he would ask the same questions that investors would ask: where's the money for this contract? And so that would indicate that he was not involved, because he's asking the same questions regarding monies and profits.
From your investigation, what do you base the fact that he was asking the same questions as the investigators? What do you base the conclusion that he was asking the same questions as the investors?
During our investigation, like we reviewed many records, we consulted many agencies, we obtained records through subpoenas or search warrants, and we were able to get text message communication held by investors, and also as a result of some subpoenas and search warrants, we were able to...
I'm going to object to any third-party involvement in this and what the other parties have done. We have not been provided with that evidence, and the witness is testifying about something that is absolute hearsay.
Sustained.
You executed some search warrants and subpoenas for cell phone records, correct?
That's correct.
Did that include the defendant and messages back and forth between her and her husband?
That is correct.
Did you use that information to reach any conclusion as to Michael Cochran's knowledge as to what was going on with their purported businesses?
We did.
How did you verify that the conversations by text were actually between the defendant and Michael Cochran? How did you authenticate those documents?
Well, the holder of those records, we would issue a subpoena or to AT&T, for example, may hold business or phone records. We would issue legal subpoenas for those to get those records, and then we would review those records.
Well, I mean, how did you know that they were communications between Mr. Cochran and Mrs. Cochran?
Well, Mr. Cochran had an established phone number. Mrs. Cochran had an established cell phone number. So the records that we requested and reviewed were those cell phone records. We also received records from investors, victim investors of the business, and would compare those to the same communication. So we had multiple text message communication, some email communication that we reviewed to come to our conclusions.
Leading right up to the 5th of February 2019, you saw text messages between the defendant and her husband?
Yes.
What was the plan? How did it end up that they were going to fly to Lynchburg, Virginia? From your investigation, how do you know that?
Let me say this scheme began in 2017. So it had gone.
I'm going to object. The witness is not answering the questions.
I think he's trying to explain, and I'll give him leeway in that regard. You may continue, Mr. Johnson.
This Ponzi scheme began in 2017, mid-2017. And as it matured, more investors gave more money. There were other monies that were obtained through some loans that Ms. Cochran would obtain. But there was still this need to return money back to the investors. The investors were still expecting money to be returned. The problem with the Ponzi scheme is it's short-lived.
Now I'm going to object. This question was asked and answered at least once.
Yeah, I think maybe we are getting a little far afield now. Perhaps another question would be in order, Mr. Truman.
Thank you. Let's just explore one other area. From your investigation, is there a single shred of evidence that supports the defendant's theory that Michael Cochran was going to turn his wife into the federal government?
No, sir, there was not.
That's all the questions the state has at this time. Thank you.
Cross-examination, Mr. Bishop.
Mr. Heinzman, I understand that you were involved in every aspect of the federal investigation of Natalie Cochran. Is that right?
I left the state police before the indictment, before she was indicted.
Before the federal indictment?
Before the actual indictment occurred, but the information that was obtained to bring that about, yes.
Prior to that, you were involved in every aspect of that investigation?
Yes, sir.
All right. So you wouldn't know what the federal government alleged in the indictment?
No, I do know what they alleged in the indictment.
Well, is it true that the federal government alleged that both Mr. Cochran and Ms. Cochran got involved in a scheme, but Mr. Cochran died, what the federal government called unexpectedly in 2019? So she was the only one who got indicted. Is that true?
I would not characterize it as such.
No.
Did you see the forfeiture documents that the federal government filed against the Cochrans?
Yes, some of those.
Some of those. And in those documents, federal government alleges that they were both involved in the scheme, right?
Without reviewing the documents, I don't know.
All right, we'll come back to this. Who is Colonel Jan Cahill?
Colonel Cahill would be the superintendent of the state police during my last employment with the state police.
I'd like to mark this
All right, if you will present it to the clerk, please.
as the defendant's exhibit number 1. I have provided a copy to the
Approach briefly, Your Honor.
Yes, you may.
May I approach?
Yes, you may.
Mr. Heinzman, I'll hand you what's been marked as defendant's exhibit number 1. Would you tell the jury what that document is?
This is a communication, a letter that I prepared and sent to a federal investigator.
That was done in April of 2019, right?
Yes. It's dated April 2019.
And the subject of your correspondence was the Tactical Solution Group and the Technology Management Solutions. Would you tell us what those two organizations were?
Technology Management Solutions, or also known as TMS, was a West Virginia company formed in 2013 by Michael Cochran and Natalie Cochran.
How about the other one?
Tactical Solutions Group, also referred to as TSG, doing business as TSG, is the company that was formed in 2017 by Natalie Cochran and Michael Cochran, which the Ponzi scheme ran through.
All right. Now, looking at this document, is it true that you allege as the mode of operation that the Cochrans, plural, Cochrans, have been soliciting contract investors to invest funds into their company to be applied to government contracts? Plural. Cochran's
Which paragraph, Mr. Victor?
mode of operation, first page.
Yes, I see that.
So they were both involved in the soliciting government contracts, right? According to you.
Well, when this correspondence was written, we began the investigation 1 month prior to this correspondence, so we're still fact-finding. We didn't conclude that Mr. Cochran was or wasn't involved that early. We went into it as if both were involved. We didn't know. We hadn't collected all the evidence, reviewed all the documents and things of that nature. So
Mr. Heinzman,
at that time, it still does list them as Cochran's.
Mr. Heinzman, this investigation has been going on since 2017. Is that right?
No, sir.
When did you start this investigation, sir?
In 2019.
2019. So 2 months before the, well, months or so before the federal indictment?
The indictment wasn't in April.
Okay. So in 2019, you're still speculating whether they're both involved in this or whether just one of them is involved?
By the time the federal